Alright, thank you. So I have an application in front of me, 2 applications. 2 summonses filed by the plaintiff in both proceedings, to reinstate proceedings which were stayed, is that correct?
That's right, Your Honor.
Alright, so the stay was lifted as a matter of course as a result of the orders of Justice Janine, is that right?
Your Honor, technically the court has to lift the stay, because the orders stayed the proceedings until the resolution of the proceedings in the magistrate's court. Whether or not the proceedings have been resolved is a matter of fact, or an issue of fact. I don't think that there's any disagreement between the parties that those proceedings have concluded. They are court orders made by the magistrate's court that also certify that.
So the stay is lifted?
Your Honor would have to make an order.
Can I hear from Ms. Kanesh, please? Please sit down.
Your Honor, that is not the first defendant's understanding. The stay as the state understands it, was made by Justice Janine, and has remained in place since that time. There has been a resolution or conclusion on the underlying proceedings, but the stay as we understand it still is in place.
Thank you.
That's our understanding too, thank you.
Thank you for clarifying that position.
So as I said, Your Honor, technically the court needs to make an order, but I think the court can make the order with consent of all parties.
And do the parties consent to the stay? What is the position of the parties? I don't believe I have draft orders.
There aren't draft orders, Your Honor.
Alright.
There has been communication between the defendants as to a proposed roadmap from this particular juncture, as to timetabling and those sorts of matters. From the defendant's perspective, what is sought at this particular juncture is that the plaintiff's formal application for the removal of the stay be timetabled with material including affidavit material, and then for a timetable allowing the defendants to file a summons in relation to applications that they seek to make to be timetabled as well.
Alright, thank you, Mr. Kuksal.
Your Honor, that is in breach of the model litigant regulations. The state has an obligation to cooperate with the court, to admit relevant matters, and to enable the resolution of the core issues in dispute expeditiously. It is not a matter of dispute that the proceedings in the underlying court have been resolved. There are court orders which are on the public record. The state is continuing. The state and the LSBC are continuing the stalling tactics that they have previously adopted in these proceedings, and if the only situation in which the court should have to list the matter on whether or not the stay out to be lifted, is if there is an actual disagreement between the parties. Otherwise, the court itself has an obligation under the Civil Procedure Act to move the proceeding along as expeditiously as possible. If Your Honor accepts that all parties are in agreement that the only underlying conditions that needed to be satisfied for the stay to be lifted have been met, then the stay should automatically be listed as a matter of course. These technicalities are not in place to create procedural hurdles for self-represented litigants, and to make the process as onerous as possible, which would be the only justifiable explanation for listing the lifting of the stay before a judge. So we strongly press that the court require the defendants to clarify whether or not they accept that the conditions for the lifting of the matter have been met, and if so, what other basis do they have for opposing consent orders for the lifting of the stay in both proceedings?
Our position is that we don't have visibility over these matters, so we haven't been in a position to consider whether to consent or not. So on that basis we consider that the appropriate application to be made is for the stay to be lifted, supported by affidavit material, and then we can consider it, but until that time we're not in a position to consent or not.
That is, Your Honor, scandalous, because I can provide to the court correspondence that was sent to the LSB over a year ago, advising them of the orders in the magistrate's court proceedings. In fact, Justice Janine has made a note in his judgment of the fact that the proceedings in the underlying court have been resolved, because I had sought to introduce that evidence before His Honor in one of the applications. So His Honor has already referred to the matter. I also refer the court to, there is actually legislation which requires the court to take notice of.
Sorry, I don't need you to point me to legislation or telling me what the court needs to do. Explain to...
Your Honor, I'm making submissions about what I am urging the court to do.
Thank you, and I'm asking you to refer me to the sections in His Honor's judgment that you're referring to.
Okay.
That would assist me.
Sure. So this is the application for extension that His Honor had.
What is the...
I'm just looking up. I believe the reasons were published on the 17th of May, 24.
Is it the 2024 VSC 253? Is that the decision that you're referring to?
I'm just looking it up, Your Honor. I believe so. I'm just confirming that I've got those reasons in front of me. Paragraph 11, Your Honor.
Just bear with me for a moment, please.
It starts from there.
Secondly, is that the paragraph? Secondly, nothing that the plaintiff or am I in the wrong decision?
So this is the citation for this judgment, is 202 VC 253.
53.
The paragraph number, Paragraph 11.
Can you read the paragraph, please?
In the memorandum of the 23rd of April 2024, the plaintiffs seek to reopen the proceeding and determine the validity of the only proceeding, that is, the Magistrates Court proceeding, number N100476659, in respect of the first plaintiff, to seek the recusal of the judge from further conduct in the proceedings, and they seek to apply for protective costs orders in the proceeding. They also state that they intend to issue subpoenas and make applications in relation to the defendant's alleged breaches of overarching obligations in the conduct of the proceeding. The plaintiffs set out errors that they contend were made in the judgment of 2023. His Honor goes on to list all the matters that were raised. Some of the matters that were raised included: the allegations included the contention that the defendants had unnecessarily dragged on the matter in the Magistrates Court and sought a stay in the Supreme Court when they did nothing to advance the case further in the Magistrates Court. At the next occasion in the Magistrates Court, they simply forfeited the proceedings, so these matters were put before His Honor. I will find an explicit reference to the fact that the proceedings had ended. But the point that I'm making, Your Honor, is that the evidence that the plaintiffs had provided to His Honor were also served on the defendants. Mr. Hogan misrepresented matters to the court when he said that they're not on notice of the fact that the cases have been withdrawn. They filed submissions in response to our submissions which had contended that the matters have been resolved, and there were court orders provided in support of that contention, and Justice Janine had accepted that contention.
So I have.
Paragraph 19. By email of the 3rd of May 2024, Mr. Cooksall informed the court that on the previous day, the prosecution had withdrawn all charges. Paragraph 19 of the same judgment. By email of the 3rd of May 2024, Mr. Cooksall informed the court that on the previous day, the prosecution had withdrawn all the charges that it had brought against him. This is in relation to the only proceeding. He attached orders of the court, exactly consistent with what I've been saying to Your Honor. Orders of the court striking out the charges and noting that they were withdrawn. He foreshadowed an application to this court for orders for the preservation and production of documents and other injunctive relief. So His Honor has seen and noted that there are orders that exist which have struck out all the charges in the Magistrates Court. I can cite the section of the Civil Procedure Act which—
Sorry, this is a directions hearing, Mr. Cooksall, so—
Your Honor, the Civil Procedure Act is applicable to this proceeding.
Thank you.
Thank you.
Your Honor, for the sake of correcting the record, what I said is we don't have visibility in respect of those matters. I didn't challenge whether or not any such application had been made.
Right.
What we need is an affidavit, essentially, some evidence which sets out what has happened in those proceedings. If we receive that and if we review that, we might be content with it. But that's what we require that satisfies ourselves, and that's, in my submission, what the plaintiffs ought be doing to allow the court to consider whether the stay ought be lifted.
Your Honor, that is scandalous. The affidavit has been lodged. They have seen the orders. His Honor has seen the orders. They are required to accept. If Your Honor could clarify from Mr. Hogan, the counsel acting for the Legal Services Board, whether he has any concern about the matters represented in paragraph 19 of His Honor's judgment, 2024, VSC 253, in which His Honor clearly states that His Honor has seen. By the way, the LSB was copied in on the correspondence that was sent to the court naturally. And His Honor notes that those charges have been lifted or have been withdrawn. Your Honor should also hear from the state, and I think if both the state and the plaintiffs accept that the charges have been withdrawn, it would further convince the Legal Services Board perhaps that the matters have been resolved. But as a matter of fact, an affidavit was lodged yesterday in the proceeding. Its exhibit, not all of them have been served. We can provide copies of the orders of the Magistrates Court, which are exhibited to that affidavit.
And the court hasn't received that affidavit yet?
The court has. It has been sealed, but because the exhibits were too voluminous, they have to be separately provided to the registry. We can provide the order part of the exhibits right now. In any event, Your Honor, the Magistrates Court order must be accepted at its face. That is the law. I can cite legislation for that. If a sealed copy of the Magistrates Court orders is received by this court, or any of the—
Do you have a copy of it there, please?
Yes, I can provide.
Can you hand it up, please?
Not a physical copy, but I can email it to Your Honor's associate right now, so I'm just emailing it.
Is this?
It's the orders of Magistrate Williams of the 2nd of May 24.
This is the one that was exhibited to the affidavit of Ms. Shu. Is that how I pronounce your name?
Yes, Your Honor. I think when we were filing the summons, there were affidavit
That's right.
sent to the court.
All right. So this is—
And the other parties were copied in.
Okay.
In filing for the summons, we also had to exhibit the orders, a copy of which was provided to the defendants. And, Your Honor, to say that they don't have visibility over a public judgment is absurd.
Sorry, I don't have a copy of the exhibit. The exhibits.
Your Honor, I'm just emailing it to Your Honor's associate. Your Honor, I've received an email from Ms. Xu to which everybody else is copied, and that email exhibits the orders of the magistrate's court.
All right. I'm going to stand this matter down for 10 minutes, so I can have a look at this material. Please sit down, Mr. Kuxel. I have to say, I am somewhat disturbed that court staff have received emails from the defendants 2 or 3 minutes prior to this hearing starting today. I have received no other material from the defendants, and I'm disappointed about that, because it seems to me that some of the matters are being raised by Mr. Kuxel, in respect of the magistrate's orders, could have been resolved without me sitting here today confusing myself, and being confused by the parties about who has received what. There is also an issue here that Mr. Kuxel has provided to the court an affidavit which does exhibit orders of the magistrate's court in one of the proceedings, which is, I'll just see if I can find it. I'm referring here to the affidavit of the 10th of February, is that right, Mr. Kuxel? Sorry, Majestaway, it's, I believe. Yes, it is your affidavit. Draft affidavit, Mr. Kuxel?
That's right, Your Honor.
Which is not. It is not sealed.
Yes.
All right.
So when we applied for the summons, we had to prepare that affidavit and provide it to the court and to the defendants.
All right. Has this affidavit been served on the defendants?
To my knowledge, yes. It has been served on the defendants.
And has it been sealed by the court yet?
No, because instead of that affidavit, the affidavit of Ms. Zhu of yesterday's date was preferred. So that affidavit included all the documents that were in the affidavit of the 10th of February, but Your Honor, in any event.
All right. So no, please, I'm trying to get my head around the documents. So the affidavit that you filed yesterday, Ms. Zhu, with exhibits that I don't have at the present time, that does exhibit the orders, is that right?
Yes.
All right. Do the defendants have copies of those orders which have they been served?
I have a copy that Ms. Xu was circulated about 15 minutes ago. The exhibits to the affidavits have not been provided to my instructor's office. We were provided with the body in effect of the affidavit.
So you have what I have, but so you do not at the present time have copies of the orders?
No, they do, Your Honor, because we've just provided them.
All right. Please sit down. Please sit down. I don't yet have a copy of the orders.
She just confirmed that she has a copy of it.
Thank you, Mr. Kuxel.
Stand up and can see it.
When I need you to speak, Mr. Kuxel, when I need your assistance, I will ask for it. I am trying to work through this material at the moment, and it's not easy.
Your Honor, I'm only trying to help because I'm aware of their tardiness.
Thank you, Mr. Kuxel. So does anybody have a copy to hand up to me of the relevant magistrate court orders?
Your Honor, I have just emailed a copy to your associate. She has confirmed that she has received it. Ms. Kananze has confirmed that she has received it too.
All right.
And, as I said earlier, Your Honor.
Please stop. No, I seem to have difficulty opening the document. So Mr. Kuxel, you just sent it to my associate, did you?
Yes, she has confirmed it.
Magistrate court orders.
Yes.
Yes. All right, from when?
And she has confirmed that she has received it.
All right.
And the defendants have confirmed that they have received it as well.
All right.
The orders. And, Your Honor, the orders are referred to in Justice Janane's orders or reasons of the 17th of May. When those applications were made, those orders were provided to His Honor and to the defendants. I can provide a copy of the emails.
So you've read it out, so by email of the 3rd of May. Mr. Kuxel informed the court that on the previous day the prosecution had withdrawn.
That's right.
The charges it brought against attached copies of the orders, striking out the charges noting they were withdrawn. Yes, I have a copy of that.
This is it. It's binding on this court, and on the...
Mr. Kuxel, I am not asking for your submissions at the moment. When I need your submissions, I will let you know.
Thank you, Your Honor.
Thank you. Okay, so, Mr. Kuxel, can you let me know which
N1
N0047659,
That's the...
Which Supreme Court is that referable to?
The one ending in 4808.
Right, so that's... I'll just call that for my own notes.
On the... Those are the only matters.
Yes.
Where Mr. Only was the informant.
On the 7th is 59 and the other one.
K12128-195 is the Magistrates Court proceeding number, in which Mr. Mayock is the informant. Mr. Mayok is the first defendant in the proceeding ending in 00183.
All right. Sit down, please. All right. Now, I have just received from my associate a proposed draft order from the defendants.
We haven't received that, Your Honor.
Defendant's proposed form of orders, has that been, sit down please. Has that been served on Mr. Kuksal?
I understand that it has.
What, is that the 2-minute A?
Please, sit down, Mr.
Your Honor, I haven't seen.
Mr. Kuksal, I am not asking you to address the court. I have another matter beginning at 2.15. I have not got all day to hear this very minor proceeding that should have been dealt with frankly on the papers. Right. Has Mr. Kuksal seen this proposed form of order?
I don't know whether Mr. Kuksal himself has seen it. It was circulated during the time that Your Honor had been stood down.
All right, so Mr. Kuksal, have you in your emails received a copy of the defendant's proposed form of order?
So, Your Honor, they were served during the hearing, is what she's saying?
Yes.
I haven't seen those, no, because I was not checking my emails during the hearing.
Right, why could...
It's absurd, Your Honor, that Your Honor had requested the...
Mr. Kuksal, I am not asking you to address me. Would it assist the parties if I stood the matter down again to enable Mr. Kuksal to have a look at the defendant's proposed form of orders?
Your Honor.
Please, Mr. Kuksal.
You just asked a question. I want to address it.
And I am asking everybody, not just you, so please sit down and give other people an opportunity. Would it assist?
Your Honor, it's a 1-page draft minute. It should only take...
Right. Well, and...
a brief amount of time.
And I will reiterate that it could have been served much earlier. Right. So would it assist the parties to resolve the orders?
Yes, we think so, Your Honor. Yes.
All right.
So, Your Honor, if the defendants are not willing to consent to a lifting of the stay, I would want that to be explicitly noted, and on reasons. They must provide the court with satisfactory reasons why they wish to.
So, Mr. Kuksal, it may be that while the matter is stood down, the parties may be able to communicate with each other.
Yes.
And come up with some proposed forms of orders to get this proceeding timetabled.
Yes.
As that is really what we're here for. And it may be.
I accept that.
I will foreshadow to all the parties that I accept. There may be applications on all sides that may be made in the lead up to trial, and the orders should accommodate that.
Sure, Your Honor, we would like to give them the opportunity to review the orders of the court, which they have previously reviewed, but in the event that they've forgotten to do that, while the court deals with the other matter.
All right. So I will stand the matter down, and during that time I hope that the parties can come up with a form of order that accommodates the issues that we've raised. And I do note that it does appear to me that there are magistrate orders, magistrate court orders, and it's not entirely clear to me that an affidavit is required exhibiting those orders in order for us to move forward.
I can cite legislation to that.
Mr. Kuksal, I just told you when I need your submissions, I will ask you.
Thank you.
Your Honor, the parties weren't able to agree upon some consent orders. We have a set of consent orders which essentially permit the plaintiffs to provide us with, not an affidavit, but with the material which supports their application to lift the stay. The second order under that permits us to look at it and then inform the plaintiffs whether we consent or not. And then subject to that, either the court makes decision with that consent, or else there's a determination of that proceeding. My learned friend and I attempted to inform the plaintiffs of the consent orders or proposed orders that we prepared, and we didn't get very far in that process. So that's the position from us. There's also a fourth order which permits, in effect, the defendants to bring summary dismissal or strikeout application. So they're the orders that we would be seeking from the court today.
All right.
Your Honor.
Please sit down. Please sit down. So the defendant's proposed form of orders that you circulated earlier, is what you're proposing now the same as that or different to that?
It's slightly different. The way that they'd been drafted in the first instance was that by a particular date, the plaintiffs were to bring a strikeout application supported by affidavit material. And I understand that there are 2 summonses that have been at least provided to us which purport to have the stay lifted. That's fine. What we've done is now essentially said, well, they can provide us with the material that supports that particular or those 2 particular applications.
The applications?
The applications to lift the stay in each of the proceedings.
Right.
We will review that material, let them know whether we consent to the stay being lifted. If we consent, then we'll let the court know, and the court can. It's essentially an order of the court that lifts the stay, so I don't know whether it can be done by consent. But we would consent to the stays being lifted in each of the proceedings. If we don't consent, then there needs to be some sort of determination based on the material the plaintiffs have provided. But that's essentially the regime that we put in place or propose to put in place.
All right, Mr.
Kuksal. Your Honor, it is absolutely scandalous for the defendants to not accept orders of the court. When they tried to, first of all, I haven't read any of the proposed orders. I asked them to verbally read them out to me from their PC, Mr. Logan, and he, Ms. Kananze, actually read out the orders. The first order was that they needed material in support of our application to lift the stay. The only condition that His Honor Justice Janane has placed on the lifting of the order is the resolution of the proceedings in the magistrate's court. Now, Ms. Kananze has repeatedly told me that she does not reject that the proceedings have been resolved in the magistrate's court. So the state, in effect, agrees that the proceedings have been resolved in the magistrate's court. She'll tell the court differently if that is the case. On Sekadzades, but that has been the state's. It cannot be any different, because they were parties to the matter. The VGSO was the instructing solicitor in the magistrate's court, and I've provided the court with a link to a recording of the court hearing where Magistrate Thomas had found that the assistant of VGSO had engaged in perversion of the course of justice in the proceedings in the magistrate's court.
I'm not sure how this...
No, Your Honor, this is an extension of a pattern of conduct. And what I told Mr. Hogan was that the State and Territorial Laws and Records Recognition Act binds this court to recognize orders of the magistrate's court. Justice Janane has noted that the magistrate's court has made those orders. So, really, from here, it's not a matter of opinion how we can proceed. The law sets a very clear path. What Your Honor has to decide right now is whether or not all parties agree on the matter of fact, which is whether or not the orders have been resolved.
All right.
If I may just complete what I'm saying. I'm not going to take very long.
Mr. Kuksal, I have a hard stop at 3 p.m. this afternoon.
Your Honor.
So you're going to need to be quite quick. This should be a simple matter of orders.
Well, it's because of them that it is. They ambushed us 2 minutes before the proceeding, deliberately.
Yes.
What material do you envisage in the first order that you were seeking that Mr. Kuksal and Ms. Shu would put on?
I suspect it would be the determinations made by the magistrate's court. Now, we've been provided with some affidavit material. That's the first time I have seen it. It may be that that's sufficient for us to satisfy ourselves.
Right, yes.
That's the only thing that I can...
So, Mr. Kuksal, what Mr. Hogan is...
No, Your Honor, that's scandalous. All that's required is the orders of the court. Justice Janane has already accepted that the proceedings have been resolved. I've read out that judgment. His side was a party to that application in the same proceeding.
Mr. Kuksal, I'm going to ask you to stop. I'm going to ask you to sit down.
Mr. Kuksal, I'm going to ask you to stop. I'm going to ask you to sit down. Mew. Your Honor, if I may just complete what I was saying for the record. What I advise Mr. Logan is that Your Honor has to decide whether or not it is possible for the parties to disagree about whether the orders have been made. And if Your Honor decides it incorrectly, we will appeal the decision. The tactics that the state is employing in these proceedings and continues to be employed, cannot be incentivized. It bring the administration of justice into disrepute.
Thank you, Mr. Kuksal.
If the material that they seek to rely on is the material that they've just provided with us, then we can do away with the first order. We would need to take instructions. I just cannot look at this material and say, I consent. We need to provide it to our clients and get the instructions. It might be sufficient simply...
It's the orders.
The second...
Mr. Kuksal.
Your Honor, Justice Janane has referred to the material. Why is he...
Mr. Kuksal.
This is misleading the court.
Mr. Kuksal, I will not tolerate...
You can kick me out. You can kick me out now. My shouting does not bring this proceeding into disrepute. They're misleading the court, and the court not doing anything to hold them to account does.
Sit down and stop interrupting.
We're content if we jump to order number 2, which is essentially the defendants inform the plaintiff whether or not we object to the stay being lifted.
No.
And we're content to do that by a particular...
No, Your Honor. This court either.
Mr. Kuksal, you do not get to interrupt. Another.
While he's misleading the court?
Mr. Kuksal, you do not get to interrupt other people, and you do not address the court until I ask you to. Now, sit down. Sit down.
Your Honor, this is a predictable path.
Right. Well, that's unfortunate then, isn't it?
Yeah, it is.
Sit down.
But I'm not. I operate on principle, and I operate very predictably.
Mr. Kuksal, if you don't sit down, I'll have you removed from the court. I simply will not tolerate what you're seeking to do here, Mr. Kuksal.
No, Your Honor. You're letting him carry on about...
Mr. Kuksal, sit down. This is your last warning.
Okay.
Sit down.
I wish to address one thing though.
Stop. Sit down now. This is your last warning before I adjourn the court and I'll have you removed. This is your—
When will I get an opportunity to address the court?
This is your last warning. Sit down or I will adjourn the court. Thank you. Mr. Hogan.
Your Honor, so we could take those instructions from our client, we could review the material that they've provided us, we could inform the plaintiffs within 7 or 14 days whether or not we—
This is ridiculous, Your Honor.
Mr. Kuksal, I have asked you to stop interrupting.
May I object?
May I object?
Does this court allow objections?
No.
Whether or not we object, if we agree, then some consent orders can be provided to the court to that effect. If we don't get agreement, then there can be a determination on the materials they've provided.
Yes. I really can't see how that prejudices the plaintiffs here. Essentially—
Your Honor, they're saying 7 or 14 days to look at just the orders which, firstly, Your Honor, in order for Your Honor to make such orders, Your Honor would have to break with Justice Janane's position.
Mr.
You're not letting me speak. You're—
No, I'm not, because I'm still just trying to engage with Mr. Hogan.
But Your Honor—
Finish that engagement. Sit down.
But you didn't give me an opportunity to—
I'm adjourning the court.
That's fine.
All right. I'm going to make some orders in this proceeding. Betties.
Your Honor, I note that I haven't addressed the court.
Thank you, Mr. Kuksal. I'm not asking you to address the court. I'm about to.
But I haven't. I want to record this for the transcript because—
Thank you, Mr. Kuksal. I'm not asking you to.
Your Honor, I want to preserve a few points.
Mr. Kuksal, stop interrupting.
I want to note that I wasn't given an opportunity
Mr. Kuksal.
to make submissions.
Mr. Kuksal, I'm removing you from the court. Thank you. While I pronounce the orders.
Okay.
I make the following orders. That the plaintiffs file any further affidavits in support of their application on or before the 25th of March 2025. The defendants will notify the plaintiffs by the 1st of April 2025, whether they consent or otherwise to the application. 3. Any further applications made by the parties filed and served on or before the 28th of April 2025. These proceedings will be adjourned to a date not before the 28th of April 2025. I'll reserve costs and give liberty to apply. Thank you for your attendance today. Is there anything further?
Nothing from us. Thank you.
Parties are excused. Thank you for your attendance.